Hey, y'all, Gary here with Tennessee Stands. Hey, look, want to talk about this National Guard issue again here real quick. As you may or may not know, the National Guard, including our guardsmen here in the state of Tennessee, are under orders to get the vaccine for COVID, or they'll be, at least for now, not paid. We don't know if they'll be dismissed yet. Per a federal court order, it seems as though they cannot be dismissed. But there's some calls being made right now by certain folks for the General Assembly to call themselves into special session without, I think, really understanding what that means or how we can really resolve this issue. So I just wanted to put a few things out there because there are some things to understand about the issue that may inform us what we can do in the meantime. And by the way, I'm going to be referencing the only thing we have going for us right now, or that at least is in the process. There was a lawsuit filed by Governor Abbott of Texas and the governor of Alaska. They sued the federal government to protect their National Guard in their states from this unlawful mandate. And so far, the federal judge in Texas has denied their request for an injunction, and that case is currently heading to an appeal. But I want to take a look at the judge's opinion that he issued on June 24th, which was just before, clearly, the June 30th deadline for the guardsmen to be vaccinated. And I want to look at the false arguments that we're accepting, which is why we keep losing these battles. We are losing these battles because we keep accepting lies, right? And let's take a look at that. First off, I'm going to take you to our state constitution, all right? And so it's important to understand that when you look at Article 3, which is the section of our Constitution that defines the powers of our governor, our executive department. Again, this is the Constitution of the state of Tennessee. You go to Section 5 of Article 3, and clearly you see, he shall be commander-in-chief of the Army and Navy of the state and of the militia, except when they shall be called into the service of the United States. And just so you understand, as defined in Title 10 and in Title 32 of our United States Code, they do refer to our state National Guardsmen as militia. So the federal government, whenever they think about the National Guard, they legally consider that the state's militia. And per our state constitution, the commander of the Army and the militia is the governor. So it's important, first off, to note that in terms of being commander-in-chief, this really isn't a General Assembly or a legislative issue. It's an executive issue. The governor is the guy right now that holds the keys to protecting the guardsmen in our state. But now what I want to do is take you to the court ruling. Because the problem is that in all of these cases that we look at in terms of vaccine mandates, which we continue to lose over and over and over again, is number one, what we've done in the past, which you'll see, and number two, the lies we continue to base these decisions on. And of course, as this judge is entering his opinion, here's his basis. So here's his quote-unquote truth that he's working off of. Of course, the vaccines are safe and effective. I mean, clearly we know this by now, that there are no side effects, there are no concerns. They're safe and effective, and that COVID-19 vaccines have received full FDA approval. Full FDA approval. We're going to get to that in a minute, but I want to keep looking at the court order. Hang on, I'm going to get back to that statement. Here's another argument that keeps shooting us in the foot, and I've seen this statement in several court documents on these vaccine mandate cases. The judge says, for the past several decades, the military has required at least 9 immunizations, such as an annual flu shot. And so I just want to put this out there. The reason that we're in this position today, it's important to understand, because Nobody wants the COVID shot mandate. We're all like, I mean, every reasonable person at this point in 2022 is against any sort of mandate for a vaccine for COVID. But the problem is, when we take these things to court, what they throw back in our face is that, but we've accepted the mandates for so long. I mean, this judge makes reference to the fact that, well, what's the big deal? For decades, the military has had 9 mandates for vaccines, including a flu shot. And many of you would acknowledge the same thing. Many of your employers, I know personally, a lot of people that I know, their employer for years has required the flu shot for employment. We've allowed requirements for vaccinations in public schools for years. And in California, they don't even have religious exemptions or medical exemptions to those vaccinations anymore. They're just required, period. And here in Tennessee, we're sort of teetering on the line of whether or not our religious exemptions are sometimes valid, depending upon if our Commissioner of Health determines that we're in an epidemic. But I won't dive into that right now. What I'm saying is, we have shot ourselves in the foot for years by already accepting the premise that anyone can mandate any vaccine. And now, all of a sudden, with everything that we've seen happen with COVID, we're concerned, legitimately concerned now, and we're against the mandates. But the court's saying, what's the big deal? Why are you all upset now, people? You've been mandated stuff, and you put up with it then. Why won't you put up with it now? Can I tell you, that's why we have to stop putting up with tyranny. That is why whenever we were under all these nonsensical mask mandates, this is why Tennessee Stands kept telling you over and over again, do not comply. Stop wearing the mask. Stop sending your kid to school with masks. Why? Because your compliance will be used against you in the court of law. What you say and what you do and what you accept, whether you like it or not, will be used against you at some point in the court of law. And so here's where we are. So that's the faulty arguments we accept. But look, the other thing is this. Well, before I get to that, let me show you one more thing. Continue with the FDA approval. So I went to Comirnaty's website. And by the way, I just got off the phone with 2 physicians, just to make sure that I'm correct. But if you go directly to Pfizer's website, and I've also searched the CDC and the FDA, but this is the best visual depiction of what I found. Pfizer itself acknowledges that Comirnaty, its version of the 16 and up version, the adult version of the shot, I'll call it, because we all know it's not a vaccine. But its adult version of the shot is FDA approved, okay? But I want to be clear. The shot authorized for ages 12 to 15 is not FDA approved. It is still for emergency use only. Now follow me here, because this is important, okay? If you stop listening to what everybody says and you just they're putting the truth here, okay? Pfizer's actually telling you the truth on their website. 12 to 15 years, it's only emergency use authorized. 5 to 11 years, it is only for emergency use. It's not, it says literally, let me read this to you. Emergency uses of the vaccine have not been approved or licensed by FDA, but have been authorized by FDA under an emergency use authorization to prevent the spread of COVID-19, blah, blah, blah. It is not approved or licensed. Ages 6 to 4 months, it is not approved or licensed. It is only authorized for emergency use. Now, before I continue this tirade, let's ask ourselves a question. We've already heard Biden say we're not in an emergency. He said it himself. We've heard Fauci say we're no longer in an emergency. We heard Governor Bill Lee say we are no longer in an emergency, and we let our emergency status lapse in terms of our legal status here in the state. All of our leaders tell us we are not in an emergency. But we continue to allow hospitals and doctors to give people shots while we're not in an emergency, shots that are only approved for use in an emergency. Are you following me? You understand what I'm telling you? Because this is the nonsense. Why are we doing any of this? Why is our state, why are our licensing boards, why is our medical licensing board here in the state of Tennessee allowing Vanderbilt Health and Ballad Health and any other medical facility and any other licensed physician to give shots to individuals that are approved only for emergency use when we are not in an emergency? How is that even happening? All right, so that's a good point to make. But further, here's the last point I want to make in terms of this mandate. The Pfizer site tells you that Comirnaty, not the Pfizer-BioNTech vaccine, but Comirnaty, is approved for 16 years and up. They also talk about Comirnaty is also labeled for use for 12 and up, and that when using the vaccine for ages 12 and up, you can interchange Comirnaty with the emergency use authorized Pfizer-BioNTech COVID-19 vaccine. But whenever you're giving a shot to a 16-year-old or older, an adult, what is FDA approved is Comirnaty. Now here's the point I'm trying to make. I just got off the phone with two physicians. I can find no proof and nowhere in the United States, at least that's broadly available, where Comirnaty is available. What we're still giving people is the Pfizer shot that is approved for emergency use, not fully FDA approved. So hear me. The shots, we say it's fully FDA approved, but that's Comirnaty. The Comirnaty label is not available. Nobody can get it, apparently. And the doctors that I'm talking to say it's not available and they can't find it. They can't get it for their patients. So where are the guardsmen getting FDA-approved Comirnaty shots under this federal mandate? Do you see the problem? Because the problem is this. The judge is predicating his ruling on the fact that the vaccines are safe and effective and have full FDA approval. But the problem is that the shots that are available to the guardsmen, that they're being mandated, are not fully FDA approved. They are shots approved for emergency use only when we're not in an emergency, and those emergency use only treatments are now being federally mandated to our military, which is unlawful. It's against federal law to mandate something that is experimental, meaning emergency use. All right, so that's the approval issue. But here's the issue in terms of how this judge sees whether or not a state or the federal government controls the Guard. Let's read this. Authority to govern the militia when called into the actual service of the United States is entrusted to the President of the United States, U.S. Constitution, Article 2, Section 2. But when the militia is not called into national service, okay, which, by the way, right now, our Tennessee National Guard has not been called into national service. They are not in an active state of military preparation. They are still under full state control. When the militia is not called into national service, federal officials lack power of, quote-unquote, governing the militia. Instead, the power of governing such a militia, albeit pursuant to federal discipline, rests with its commanders under state law. And as I read to you in our state constitution, that would be under the command of Governor Bill Lee, not President Joe Biden. Let's continue. The judge says, when not federalized, again, which they are not currently federalized, National Guard members remain in so-called Title 32 status. They are governed by their state commander-in-chief, our governor, not our federal agencies. Let's keep going here. There was another point I wanted to make. Okay, here's the problem. Yes, here's the issue. So here's where we are, and here's where I want to close. If we're going to call a special session of the General Assembly, here's why we could do it, or why we would do it, and what I feel like the General Assembly could do. There's really only one real decision to make here. The judge says plaintiffs and defendants agree that the executive actions do not allow the military officials to order a non-federalized National Guard member to be imprisoned for disobedience. Plaintiffs and defendants also agree that the executive actions do not impose a vaccination requirement for militia activities not funded by the federal government. All right, so that's good. It sounds like we're winning our argument so far. But here's the problem. Plaintiffs do not dispute that requiring guardsmen to be vaccinated against COVID-19 falls within defendants' statutory authority to impose readiness requirements. Now, so here's where we start to lose. So the plaintiffs, the state of Texas, who are supposed to be defending their guardsmen, are now relenting the argument. They're saying, oh, well, but yeah, we agree, I guess, in principle, that in terms of making our military ready, that the federal government does have the ability to impose vaccination requirements. And then here's what they also say. They are not disputing that the federal government may add the COVID-19 vaccination to the list of standards prescribed for guardsmen under Title 32. So here's the complete breakdown. We're fighting for our rights, and we're suing the federal government, but now we're saying, well, yeah, but I guess they really can still make a vaccination requirement because that is under their federal duty to do so. And what we're doing is we're continuing to buy the lie that, number one, that the federal government or anyone else can make medical mandates over the population. And number two, we're buying into the lie that these are FDA-approved treatments when they're not. But here's the real root of the argument. So if you read the rest of this 12-page opinion, the judge acknowledges that the only real power here of the federal government is to pull federal funding. And so here's what I would submit, my humble opinion, that the General Assembly could do, and here's what I think we should do. Our National Guardsmen right now in Tennessee that are under threat of not being dismissed from the National Guard because they can't really do that yet, but they're going to be not paid. They're going to be unpaid guardsmen because the federal government, because of their refusal to be vaccinated, is going to pull federal funds, which they can. And this is the challenge. This is the challenge that all of us are going to continue to be in terms of defending our rights, is our subjectivity, the way we've subjected ourselves to federal funding. Our rights, how we educate our children, our healthcare system. We operate on about a $53 billion budget in the state of Tennessee. That was the last budget that was passed, about $53 billion. $20 billion of those dollars is federal funding. $20 billion. About 10% of our education throughout the state is federal funding. And my understanding from folks is that about 60% of our health care here in the state is funded by Medicare and Medicaid. 60%. When you add all of that up, what it means for you and me as a Tennessean is that we're subject to the federal government. When you are a Tennessee National Guardsman, but you are paid by federal funds, here's what that means. Your rights are subject to federal funding. That all needs to change. And of course, we can't change that today immediately, but we need to take some serious steps to changing that. But what the General Assembly can do is come into session, and guess what we should be doing with our tax dollars? Instead of giving $1 billion to Ford, instead of giving $500 million to the Tennessee Titans, guess what would be an appropriate use of our taxpayer dollars, since we seem to operate on a $2 to $3 billion surplus here in Tennessee? Pay our National Guardsmen. Pay our National Guardsmen until we get a court to put an end to this nonsense, which God help us. I hope we're going to get there. But until we do get there, what we can do as Tennesseans is Tennessee can step up and pay our National Guardsmen who are refusing to be vaccinated, by which they're now going to be unpaid because the federal government is going to pull that funding because they are not subjecting themselves to an experimental treatment. Just be frank. If you're listening, members of the Tennessee General Assembly, I hope you will consider that action. As a taxpayer, I would just say I much more support you paying men and women who are putting themselves on the front line to provide for our common defense, if in so it's needed. If it is called upon them to do so, let's pay them to do that. And let's stop sending our tax dollars to private corporations to fund their wealth. Let's not do that, but let's fund our common defense. That's an appropriate use of tax money. So that's what I think should be done. I hope you will call your state representatives and state senators and encourage them that if they are going to call themselves into special session to deal with this issue, that they strongly consider appropriating our budget here in the state to pay these men and women while this nonsense is sorted out in the courts. Otherwise, we're going to lose some really good folks that have signed up to defend the state and our country should we need. And God help us, we're in tumultuous times. The last thing that I want to see happen is have good, solid men and women who simply want to make their own medical decisions removed from their duty, removed from their post simply because they won't take a shot. I hope that's been helpful. At the end of the day, we need to stop making court rulings and agreeing to rulings that are based on lies, that are based on things that are not even true. And secondly, I implore you, Tennesseans, stop complying with unlawful, unconstitutional orders, because every time you do so, you continue to put us all at risk of our liberties being taken away and courts in the future continuing to use our compliance against us whenever we challenge our government for the sake of our liberty. God bless you.